The gavel strikes mahogany with the authority of centuries. But Judge Cornelius Whitmore's voice cuts deeper than wood grain. "Miss Blackstone, was it? I'm going to stop you right there. This is a court of law, not a community college debate class." Victoria Blackstone stands at the defendant's table, a manila folder clutched in hands that don't shake. She's 32, dressed in a thrift store blazer that's seen better decades, her natural hair pulled back in a simple ponytail. To everyone in Montgomery County Circuit Courtroom 4A, she looks exactly like what Judge Whitmore thinks she is, an undereducated woman in over her head. I strongly advise you to reconsider representing yourself in this inheritance dispute. These are complex matters of probate law far beyond. Well, let's just say they require substantial legal training. The courtroom gallery holds its collective breath. Opposing counsel Maxwell Thornfield, resplendent in his $1,500 suit, suppresses a smirk. The court reporter Sage Millfield types steadily, documenting every word of what she's beginning to suspect is judicial misconduct. In the front row, 3 men in dark suits observe with the stillness of predators. "Your Honor, I understand the complexity. However, Maryland Code Section 3-101 clearly states, 'Miss Blackstone, please, don't embarrass yourself by attempting to cite law you've clearly Googled 5 minutes ago. Mr. Thornfield, explain to this young lady why she needs proper representation.'" But Victoria's eyes hold something Judge Whitmore doesn't recognize. Behind her quiet demeanor lurks the steel of someone who's been underestimated before, professionally. Her fingers tap against her folder in a precise rhythm, and for just a moment her posture shifts. It's subtle, almost imperceptible, but to a trained observer, it's the stance of someone accustomed to command. The lock of justice clicks twice, then silence. 7:43 a.m. Victoria Blackstone approaches the steps of Montgomery County Courthouse, her worn leather briefcase clutched firmly in her right hand. Most people would see a working-class woman dressed in department store attire, but her eyes sweep the building's entrances and exits with methodical precision. She notes the positions of security cameras, counts the number of courthouse personnel entering through the main doors, and mentally catalogs the placement of every emergency exit. Old habits die hard when they've been drilled into your consciousness through federal training protocols. The morning air carries the weight of August humidity, but Victoria moves with purpose through the revolving doors. Her gait is measured, economical, the walk of someone who knows exactly where they're going and has calculated the most efficient route to get there. To casual observers, she appears to be another nervous litigant preparing for what could be the most important day of her life. They don't notice the way she assesses potential threats, identifies law enforcement personnel, or positions herself with clear sightlines to all exits. Inside, the courthouse bustles with the controlled chaos of justice in motion. Lawyers in expensive suits rush between elevators, their briefcases stuffed with billable hours and barely contained ambition. Plaintiffs and defendants clutch documents with white knuckles, their faces etched with the uncertainty that comes with having your fate decided by strangers who may not care about your circumstances. At the information desk, Deputy Clerk Sloan Aldrich barely glances up from her computer screen. She's 43 years old, divorced twice, and deeply resentful of having to deal with pro se litigants who don't understand the complexity of legal procedure. In her experience, people representing themselves are usually either too poor to afford lawyers or too arrogant to realize they need professional help. "Can I help you? I'm here for the Blackstone versus Thornfield inheritance hearing." Courtroom 4A. Aldrich's fingers hover over her keyboard, her expression shifting from bored indifference to something approaching disdain. The name Thornfield carries weight in this courthouse, the kind of weight that comes with political connections, substantial campaign contributions, and the ability to make careers or destroy them with a single phone call. "You're representing yourself?" "That's correct." "Against Maxwell Thornfield's firm?" Aldrich's tone carries the weight of disbelief mixed with something that might be pity. "Honey, you might want to reconsider. These inheritance cases can get complicated fast. There are procedures, deadlines, rules of evidence, things that take years of law school to understand properly. I'm familiar with the requirements." Victoria's voice remains level, but there's steel underneath the calm, the kind of steel that comes from years of facing down hostile situations with nothing but preparation and determination. "Could you direct me to the appropriate filing office? I need to submit some last-minute documentation." The clerk's eyebrows rise in surprise. Most pro se litigants come in scared, confused, clutching printouts from legal advice websites and hoping someone will take pity on them. This woman speaks with quiet confidence, using terminology that suggests she actually understands what she's talking about. "What kind of documentation?" Motion to compel discovery. The opposing counsel has been less than forthcoming with certain financial records. Aldrich leans back in her chair, studying Victoria with new interest. Motion to compel discovery isn't something you learn from an internet search. It requires understanding of procedural rules, proper formatting, and knowledge of what constitutes discoverable evidence under state law. Down the hall, room 123. But you'll need proper formatting, correct citations, appropriate service of process. There are very specific requirements for these kinds of motions. One mistake, and the judge will throw it out without consideration. Thank you. Victoria turns away before Aldrich can finish her lecture. As she walks down the marble-floored hallway, her briefcase swings at her side with the weight of more than just legal documents. Hidden in a specially constructed compartment, undetectable to courthouse security but accessible with the right combination, are items that would raise serious questions if discovered during a routine search. Room 1. 23 houses the civil filing office, where a harried clerk named Marcus Webb sorts through stacks of motions, complaints, and appeals with the mechanical efficiency of someone who's processed thousands of similar documents. He's seen every type of litigant imaginable, from sophisticated corporate lawyers to desperate individuals trying to navigate a system that seems designed to confuse rather than clarify. When Victoria approaches his window, he doesn't bother looking up from the motion he's currently reviewing. What do you need? Filing a motion to compel discovery. She slides a perfectly formatted legal document through the slot beneath the bulletproof glass, with appropriate copies for opposing counsel and service certification. Webb glances at the motion, then does a double take that would be comical if the implications weren't so serious. The formatting is flawless. The citations are precise. The legal arguments are sophisticated enough to have come from a senior partner at a major firm, complete with supporting case law and statutory references. Did you have help preparing this? No. Because if you received assistance from an attorney, there are disclosure requirements under Rule 1-3-2. Failure to disclose can result in sanctions, dismissal, even criminal charges for fraud upon the court. I prepared it myself. Webb continues reading, his frown deepening with each paragraph. The motion cites federal precedent, state appellate court decisions, and obscure procedural rules that most practicing attorneys would need to research extensively. The writing style is crisp, professional, and demonstrates a sophisticated understanding of civil procedure that takes years to develop. This is very well done. Where did you study law? Is there anything else you need for filing? Webb stamps the motion with mechanical precision, but his eyes never leave Victoria's face. He's processed thousands of legal documents over 15 years of courthouse employment, and he's never seen anything like this from a pro se litigant. The quality of her work rivals anything produced by the most expensive law firms in the state. She pays the filing fee in exact change, another small detail that suggests careful preparation, and walks away, leaving him staring after her with growing confusion and a nagging suspicion that something significant is happening beyond his understanding. Are you seeing this? A federal judge just humiliated someone in his own courtroom, but something tells me this woman isn't who she appears to be. The way she's taking notes, that's not random. Keep watching, because what happens next will blow your mind. Hit that like button if you're already hooked. Courtroom 4A occupies the courthouse's third floor, its double doors bearing the brass nameplate of Judge Cornelius Whitmore and the weight of judicial authority. Victoria arrives 30 minutes early, another calculated decision based on operational planning that has become second nature. She chooses a seat in the gallery rather than immediately taking her place at the plaintiff's table, using the time to observe the room's dynamics with the attention of someone conducting tactical reconnaissance. The courtroom itself reflects traditional judicial architecture, high ceilings, mahogany paneling, and formal portraits of deceased judges whose stern expressions suggest that justice has always been a serious business requiring serious people. The witness stand sits elevated above the main floor, designed to emphasize the importance of testimony and the authority of those who sit in judgment. The three men in dark suits arrived before her, despite her early arrival time. They sit separately, scattered throughout the gallery in positions that provide optimal sightlines while maintaining the appearance of casual attendance. To untrained observers, they appear to be lawyers, investigators, or interested parties connected to other cases. Victoria notices the subtle ways they communicate: an adjusted collar indicating readiness, a shifted position signaling awareness of new arrivals, hand signals disguised as casual gestures that coordinate their surveillance without drawing attention. She files this information away in the part of her mind trained to catalog potential threats and assess operational security. Their presence confirms what she's suspected for months. The corruption they're investigating extends beyond individual bad actors into systematic institutional failure. Judge Cornelius Whitmore enters at exactly 9 a.m., his black robes billowing with self-importance and the accumulated weight of 23 years on the bench. He's 67 years old, appointed through political connections rather than judicial excellence, and his reputation precedes him like the wake of a sinking ship. Harsh sentences for defendants of color, lenient treatment for white-collar criminals, and a documented history of comments that dance along the line of outright racism while maintaining just enough plausible deniability to survive judicial review. Maxwell Thornfield follows moments later, flanked by two junior associates whose combined law school debt exceeds most people's annual salaries. Thornfield himself is a study in expensive tailoring and cultivated arrogance. 54 years old, Harvard Law School graduate, and senior partner at a firm that has built its reputation on representing wealthy families in estate disputes. They win because they outspend, outmaneuver, and outconnect their opponents, turning the legal system into a private club where membership is determined by net worth rather than merit. Today, they expect to crush a waitress from the wrong side of town who has the audacity to challenge their carefully constructed narrative about family dynamics and inheritance rights. All rise for the Honorable Judge Cornelius Whitmore. Bailiff Camden Ross commands the room with practiced authority. He's worked this courtroom for 15 years, long enough to recognize the patterns of bias that flow from the bench like water from a poisoned well. Ross is 51 years old, a military veteran who took the bailiff position after retiring from the Army with full pension and a deep respect for constitutional principles that sometimes conflicts with the reality of his current employment. Be seated. Court is now in session. Case number 2024-3785. Blackstone v. Thornfield Estate Management, LLC. This is an inheritance challenge regarding the estate of Viola Mae Blackstone, deceased. The formal language of judicial procedure fills the courtroom with ceremonial gravity. For most people present, these words represent the beginning of a process that will determine the distribution of significant wealth. For Victoria Blackstone, they represent the culmination of 18 months of careful preparation and the beginning of the most dangerous phase of an undercover operation that has already gathered enough evidence to destroy multiple careers. Thornfield rises with theatrical flourish, his movement calculated to command attention and establish dominance. Your Honor, Maxwell Thornfield representing Thornfield Estate Management and the legitimate heirs of the deceased. We move for immediate dismissal on the grounds that the plaintiff lacks standing to challenge the will and has failed to state a claim upon which relief can be granted. Your Honor, Victoria stands, her voice carrying clearly through the courtroom with the kind of projection that suggests professional training in public speaking. Victoria Blackstone, representing myself. I respectfully disagree with counsel's characterization of my standing under Maryland Code Section 3-405. Judge Whitmore's gaze fixes on her with the intensity of a hawk spotting movement in tall grass. This is not how these proceedings typically unfold. Pro se litigants usually stumble through basic objections, struggle with procedural requirements, and eventually accept whatever settlement the opposing counsel offers out of exhaustion and intimidation. Miss Blackstone, before we proceed any further, I must ask, are you absolutely certain you wish to represent yourself in this matter? Probate law is notoriously complex, and Mr. Thornfield's firm has considerable resources at their disposal. I'm prepared to proceed, Your Honor. I see. Whitmore's tone carries the weight of judicial disapproval mixed with something that might be curiosity. Very well, but I want it clearly on the record that this court advised you to seek proper legal representation. The complexities of estate law, rules of evidence, and civil procedure are not matters that can be mastered through casual research. The warning is both legal requirement and tactical intimidation. By emphasizing the complexity of the proceedings and her apparent lack of qualifications, Judge Whitmore is creating a record that will support his eventual ruling against her while establishing grounds for her to blame herself rather than judicial bias when she inevitably loses. Speaking of legal protection, today's video is sponsored by Legal Shield. Whether you're facing discrimination, workplace issues, or need legal advice, Legal Shield connects you with experienced attorneys 24/7. For less than $1 a day, you get access to legal consultation, document review, and representation. Don't wait until you're in a courtroom like our protagonist. Visit LegalShield.com/justice and get your first month free, because everyone deserves proper legal representation. The first skirmish begins immediately as Thornfield produces a motion designed to exclude Victoria's evidence on procedural grounds. It's a standard intimidation tactic designed to overwhelm pro se litigants with technical complexity while establishing the superiority of professional legal training over amateur preparation. Your Honor, Thornfield begins, his voice dripping with condescension, carefully modulated to sound helpful rather than hostile. The plaintiff has submitted various documents purporting to establish her relationship to the deceased and the circumstances surrounding the will's execution. However, these documents lack proper authentication under Maryland Rule 5-901. Without proper foundation testimony from custodians of records, chain of custody documentation, and expert verification, Your Honor, Victoria interrupts smoothly, her interjection timed with precision that suggests familiarity with courtroom tactics. Opposing counsel is mischaracterizing the authentication requirements. Maryland. Rule 5-901 permits self-authentication for public records under subsection 9, which includes the birth certificates and death certificates I've submitted. Furthermore, the business records exception under Maryland Rule 5-803 covers the financial documents in question, provided they meet the reliability standards established in State v. Morrison. 275 Maryland reports. Page 412. The courtroom falls silent except for the steady clicking of Sage Millfield's stenographic machine. Thornfield's mouth opens, then closes. Judge Whitmore blinks twice, his prepared ruling to exclude Victoria's evidence suddenly complicated by her precise citation of procedural law and supporting case precedent. Well, Thornfield recovers with the practice, not the smoothness of someone accustomed to adapting when initial tactics fail. Even assuming the documents are admissible, the plaintiff must still establish the 4 elements of undue influence under Maryland Code Section 3-405. Susceptibility to influence, opportunity to exert influence, disposition to exert undue influence, and a result appearing to be the effect of such influence, which I'm prepared to establish through testimony and documentary evidence. Victoria continues without missing a beat, her response delivered with the confidence of someone who has anticipated every possible objection, including medical records documenting the deceased's cognitive decline, financial records showing unusual transfer patterns in the final months of her life, witness testimony regarding isolation from family members, and evidence of systematic manipulation by interested parties. Judge Whitmore's frown deepens as he realizes that his standard approach, allowing opposing counsel to overwhelm pro se litigants with procedural complexity, isn't working as expected. This woman not only understands the law but can articulate legal arguments with precision that rivals experienced practitioners. Miss Blackstone, the judge says slowly, his words carefully measured to conceal his growing concern, where exactly did you acquire this knowledge of probate procedure and evidence law? For the briefest moment, less than a second, but noticeable to trained observers, Victoria's mask slips. Her answer comes too quickly, with the practiced delivery of someone accustomed to providing cover stories under pressure. I've done extensive research, Your Honor. The public library has excellent legal resources, and Maryland Legal Aid provides guidance materials for pro se litigants. It's technically true, but incomplete. The 3 federal agents in the gallery notice the pause before her answer. They notice the way her eyes move when she speaks, scanning the courtroom with tactical awareness rather than the nervous uncertainty typical of self-represented parties. They notice behavioral patterns that confirm intelligence gathered over months of surveillance and investigation, but they say nothing. Their role is to observe, document, and wait for the operation to reach its predetermined conclusion. The hearing progresses with uncomfortable tension as Judge Whitmore finds himself in the unusual position of having to actually consider legal arguments rather than simply ruling in favor of the better-connected party. Thornfield, meanwhile, grows increasingly frustrated as his standard tactics fail to intimidate an opponent who seems immune to the psychological warfare that typically characterizes complex litigation. Your Honor, Thornfield tries again, his voice carrying a note of desperation carefully disguised as legal concern. I move to continue this hearing pending the plaintiff's retention of qualified counsel. It's clear that the complexity of these proceedings exceeds what can reasonably be expected from someone without formal legal training. Motion denied. The words surprise everyone in the courtroom, including Judge Whitmore himself. Under normal circumstances, he would have granted the continuance, giving Thornfield's team time to develop stronger arguments while pressuring Victoria to accept an unfavorable settlement. But the law is the law, and Victoria has demonstrated sufficient competence to proceed despite his personal preferences. Miss Blackstone, you may present your opening statement. Victoria rises, her movements economical and precise, the physical bearing of someone accustomed to maintaining composure under pressure. Your Honor, this case centers on the systematic manipulation of an elderly woman by trusted advisors who exploited her declining mental capacity for financial gain. The evidence will show that Viola Mae Blackstone's final will was executed under circumstances that meet every element of undue influence under Maryland law. She speaks for exactly 7 minutes, outlining her case with the clarity of a prosecutor and the passion of someone seeking justice for family. Her arguments are cogent, her evidence outlined systematically, and her presentation professional enough to have come from a senior litigator with decades of courtroom experience. When she finishes, Thornfield's confident smirk has transformed into something approaching genuine concern. "Mr. Thornfield," Judge Whitmore says, his voice carefully neutral as he struggles to maintain judicial impartiality while favoring his preferred outcome. "Your opening statement." Thornfield rises, adjusting his silk tie with practiced arrogance that speaks to decades of successful intimidation. "Your Honor, what we have here is a classic case of sour grapes. Miss Blackstone's aunt disinherited her for good reason. A pattern of irresponsible behavior, broken promises, and financial instability that made it clear she was unfit to inherit substantial assets." His words are calculated to wound, designed to paint Victoria as a greedy relative seeking money she didn't earn, while reinforcing class-based prejudices about worthiness and entitlement. In most courtrooms, with most judges, the strategy would be devastatingly effective. The narrative is simple, believable, and reinforces existing assumptions about people who challenge established authority. The will was properly executed, properly witnessed, and properly filed according to Maryland law. Miss Blackstone's claims of undue influence are nothing more than the desperate allegations of someone who thought family ties meant automatic entitlement to wealth she had no role in creating. But something unexpected happens during Thornfield's character assassination. Victoria doesn't flinch. She doesn't react with hurt or anger or indignation. Instead, she takes notes with the detached professionalism of someone documenting evidence for future use. Her pen moves across her legal pad in precise strokes, recording not just Thornfield's words, but his mannerisms, his assumptions, his tactical approaches. The bailiff notices. The court reporter notices. Even some members of the gallery notice that the supposed grieving niece is analyzing opposing counsel with the cold precision of a chess master studying an opponent's opening moves. Judge Whitmore gavels the proceedings to a brief recess, and the courtroom empties into the hallway. Lawyers huddle with clients, witnesses review their testimony, and court personnel prepare for the evidentiary phase of the hearing. Victoria remains seated, continuing her notes with methodical thoroughness. The 3 federal agents drift past her table during the recess, close enough to observe but far enough to maintain operational security. What they see confirms their growing certainty about the true nature of the operation unfolding before them. Victoria's notebook contains more than legal arguments. It includes behavioral analysis, tactical assessments, and observational details that suggest training far beyond library research. When court reconvenes, Thornfield calls his first witness, Margaret Hayes, a supposed friend of Viola Mae Blackstone who claims to have witnessed the elderly woman's clear mental capacity and firm intention to exclude Victoria from her inheritance. Hayes is well-dressed, well-spoken, and utterly convincing in her testimony about Viola's rational decision-making process and explicit statements about family members who had disappointed her. There's only one problem with Hayes' compelling testimony. The affidavit she signed contains dates and details that don't match hospital records, security footage, or basic chronological reality. Victoria rises for cross-examination with the calm precision of a surgeon approaching a complex operation. "Miss Hayes, you testified that you visited my aunt on March 15th of this year, correct?" "Yes, that's right." "And you stated that she seemed mentally sharp, able to discuss complex family matters and financial decisions?" "Absolutely. She was completely coherent, fully aware of her circumstances and the implications of her decisions." "I see." Victoria approaches the witness stand carrying a manila folder with the systematic preparation of someone who has anticipated every possible scenario. "Miss Hayes, I'm going to show you what's been marked as Plaintiff's Exhibit 7. Can you identify this document?" Hayes glances at the paper, her confidence wavering slightly as she recognizes official medical documentation. It appears to be some kind of medical record. Specifically, it's a hospital admission record from Montgomery General Hospital. "Can you read the patient's name and the date of admission for the record?" Hayes' face goes pale as she realizes she's walking into a trap that has been months in preparation. "Viola Mae Blackstone, March 13th, 2024. "And the discharge date?" "March 22nd, 2024. "So, according to these certified medical records, my aunt was hospitalized from March 13th through March 22nd. In a medically induced coma following complications from her diabetes medication and kidney failure." The courtroom erupts in whispers and shuffling papers. Thornfield leaps to his feet with the desperation of someone watching a carefully constructed case collapse in real time. "Objection! This document hasn't been properly authenticated. We haven't had a chance to examine the chain of custody, verify the accuracy. Your Honor, Victoria's voice cuts through the chaos with judicial authority that silences the room. This is a certified copy of a public record obtained directly from Montgomery General's Medical Records Department. It bears the hospital's official seal, custodian certification, and is self-authenticating under Maryland Rule 5-902. Judge Whitmore examines the document, his frown deepening as he realizes that the medical record is genuine, properly certified, and completely contradicts witness testimony he was prepared to accept without scrutiny. Miss Hayes? The judge asks slowly, his words carrying the weight of someone beginning to understand the magnitude of perjury occurring in his courtroom. If Miss Blackstone was in a medically induced coma on March 15th, how exactly did you have a lucid conversation with her on that date? Hayes's mouth opens and closes silently, her eyes darting toward Thornfield with the desperation of someone seeking rescue that isn't coming. The trap has closed with mechanical precision, and everyone in the courtroom can see it. I must have been mistaken about the date. Mistaken? Victoria's voice remains level, but there's prosecutorial steel underneath the calm. Miss Hayes, how many visits did you make to my aunt's home during the final year of her life? Several. I can't remember the exact number. More than 5? Probably. More than 10? Yes, possibly. Victoria opens another folder, producing a stack of documents that represent months of investigative work. Miss Hayes, I'm showing you what's been marked as Plaintiff's Exhibits 8 through 15. These are security camera recordings and visitor logs from the gated community where my aunt lived. Every visitor is logged electronically with timestamps, license plate numbers, and photographic identification. Can you point out any record of your visits to 1723 Maple Grove Drive? The silence stretches like a taut wire as Hayes stares at the visitor logs with growing horror, realizing that her fabricated testimony has just collided with digital evidence that cannot be disputed or explained away. Your Honor, Thornfield says desperately, these documents are highly prejudicial and these documents are evidence of perjury, Victoria responds with devastating calm. Miss Hayes has testified under oath to multiple visits that never occurred, conversations that never happened, and mental states she never observed. Judge Whitmore's face has transformed from judicial neutrality to something approaching alarm as he realizes that what began as a simple inheritance dispute has suddenly become a case involving witness tampering, document fraud, and potential criminal conspiracy. Miss Hayes, the judge says carefully, his words chosen with the precision of someone who understands that everything he says is being recorded for potential appellate review. I'm going to ask you one more time. Did you ever visit Viola Mae Blackstone at her residence? Hayes's voice comes out as a whisper. No, Your Honor. Did you ever speak with her about her will or her intentions regarding inheritance? No, Your Honor. So your entire testimony regarding her mental capacity and expressed intentions was fabricated? The word fabricated hangs in the air like poison gas. Hayes begins to cry, but they're not tears of remorse. They're tears of someone who has just realized they've been caught in a federal crime that could result in years in prison. Before we continue, let's talk about protecting your financial future. Life insurance through Policy Genius can secure your family's stability in minutes. Compare quotes from top insurers, get unbiased advice from licensed agents, and apply online. Whether you're starting a career or planning retirement, Policy Genius makes life insurance simple and affordable. Visit policygenius.com/secure today and get personalized quotes in under 5 minutes. Your family's financial security shouldn't wait. Your Honor, Thornfield attempts damage control with the frantic energy of someone watching his career implode. My client was obviously confused under stress from the emotional weight of testifying about a deceased friend. Your client committed perjury in my courtroom, Judge Whitmore snaps, but his anger isn't directed at the witness who lied. It's directed at Victoria, who exposed the lie with embarrassing efficiency that threatens to reveal the systematic corruption underlying his judicial authority. Miss Blackstone, the judge says, his voice dripping with barely concealed hostility, where exactly did you obtain these security recordings and visitor logs? From the property management company, Your Honor. They're required by law to maintain visitor records for insurance purposes and resident security. And you knew to request these specific records because the question hangs in the air, loaded with suspicion and the growing awareness that normal people don't think in terms of digital evidence preservation or chain of custody documentation. Victoria's answer comes with the same practice delivery as before, smooth but incomplete. I wanted to verify the witness's claims, Your Honor, but it's not the whole truth, and the 3 federal agents in dark suits know it. Ordinary citizens don't automatically consider security camera footage when planning legal strategy. They don't speak the language of authentication and evidence preservation with such fluent precision. They don't conduct investigations with the systematic thoroughness of law enforcement professionals. Judge Whitmore calls for another recess, but this time his demeanor has shifted from reluctant fairness to active hostility. He's beginning to suspect that he's being played in a game whose rules he doesn't understand, though he can't quite identify the nature of the threat or the identity of his opponent. In chambers, he conducts a heated conference with Thornfield, their voices carrying through the thin walls despite efforts at secrecy. "This was supposed to be simple," Whitmore hisses with the venom of someone whose carefully planned corruption is being exposed by amateur investigation. "A quick ruling, minimal scrutiny, standard estate transfer to your clients." "She's not what we expected," Thornfield admits, his voice carrying the strain of someone realizing that months of preparation have been wasted. Her preparation level suggests professional assistance, investigative resources, access to records that normal people can't obtain. Then find out who's helping her, run background checks, contact your investigators, use whatever resources you have. "I want to know everything about Victoria Blackstone by tomorrow morning." What they don't realize is that Victoria Blackstone has been running background checks on them for 18 months. Every financial transaction, every case decision, every private meeting has been documented with federal precision. The trap they're trying to spring was set long before the first gavel fell. When court reconvenes, Judge Whitmore's mask of judicial neutrality has slipped completely, replaced by the naked hostility of someone who feels his authority challenged by forces beyond his control. "Miss Blackstone," he begins, his words carefully chosen to sound judicial while carrying unmistakable menace. "I find your sudden expertise in evidence law quite remarkable for someone who claims to be self-taught. Are you certain you haven't received professional assistance in preparing this case?" "I've represented myself throughout this proceeding, Your Honor." "I see. And your familiarity with security protocols, medical record authentication, visitor logging systems, this all comes from public library research?" The courtroom grows tense as everyone present can feel the shift in judicial temperament, the transformation from reluctant fairness to active intimidation. Members of the gallery exchange uncomfortable glances, sensing that they're witnessing judicial authority being used as a weapon rather than a tool of justice. "I've done extensive preparation, Your Honor." Extensive preparation. Judge Whitmore's voice carries the weight of judicial authority mixed with personal animosity. "Miss Blackstone, in my 23 years on this bench, I've seen thousands of pro se litigants. Most struggle with basic procedure, fundamental concepts of evidence law, even proper courtroom etiquette. Yet you seem remarkably well versed in complex evidentiary standards, almost as if you have professional legal training that you're concealing from this court." "Your Honor, Let me be direct, Miss Blackstone. I'm beginning to suspect that you're receiving unauthorized assistance, ghostwriting, shadow representation, coaching from qualified attorneys who don't want their names on the record." The accusation hangs in the air like an executioner's blade. Unauthorized assistance is a serious charge that could result in case dismissal, financial sanctions, and even criminal prosecution for fraud upon the court. "Your Honor," Victoria responds with carefully controlled calm that speaks to years of training in managing hostile interrogations. "I've prepared this case myself using publicly available legal resources. If the court doubts my competence to proceed, I respectfully request specific examples of procedural deficiencies in my presentation." It's a masterful response that turns defense into offense. Instead of defensive denial, she's challenged the judge to identify actual problems with her legal work. If her preparation is genuinely deficient, he should be able to point out specific errors. If he can't, his accusations amount to speculation based on prejudice rather than evidence. Judge Whitmore realizes he's trapped himself in a logical corner. Victoria's legal work has been flawless. Her citations are accurate, her procedures correct, her arguments cogent. To claim incompetence, he would need to identify actual mistakes that don't exist. So he changes tactics, abandoning legal justification for naked judicial bullying. "Miss Blackstone, this court operates on the principle that parties should be represented by qualified legal professionals. While you have the constitutional right to represent yourself, I strongly question whether it serves the interests of justice to allow complex inheritance disputes to be litigated by individuals lacking formal legal training." Translation: "You're too competent for your own good, and I don't like it." "Your Honor," Victoria responds with the quiet authority of someone who understands constitutional law better than the judge questioning her. The Sixth Amendment guarantees the right to counsel. but the 14th Amendment guarantees the right to self-representation. The Supreme Court confirmed in Ferretta v. California that defendants have the constitutional right to proceed without counsel when they voluntarily and intelligently elect to do so. This is a civil proceeding, Miss Blackstone. Correct, Your Honor, which makes the right to self-representation even stronger, since civil litigants don't enjoy the same constitutional protections as criminal defendants, but retain fundamental due process rights under the 14th Amendment. Judge Whitmore's face flushes with anger as he realizes that not only has she corrected him on basic constitutional law, but she's done it with the quiet authority of someone who actually understands the legal principles involved better than he does. The three federal agents in dark suits exchange subtle glances, their silent communication confirming what months of surveillance have established. The woman at the plaintiff's table isn't what she appears to be, and the game being played is far more complex than a simple inheritance dispute. Agent Morrison rises and exits the courtroom, reaching for his secure phone before the doors close behind him. The call he makes will trigger events that have been 18 months in preparation. This is making my blood boil, watching someone get treated like this because of prejudice and assumptions. But notice how calm she stays. There's something powerful brewing here. If this injustice is getting to you too, smash that subscribe button. Trust me, you'll want to see how this ends. The social pressure in the courtroom has reached a breaking point. Gallery members whisper among themselves, their conversations creating a low buzz that could be directed at either the judge's obvious bias or Victoria's apparent presumption in challenging established authority. Local media representatives take notes, sensing that routine inheritance proceedings have transformed into something newsworthy. Thornfield senses the moment and strikes with the calculated precision of a predator sensing wounded prey. Your Honor, I hate to raise this matter, but I feel obligated to inform the court that my investigation has revealed certain irregularities in Miss Blackstone's background that may be relevant to her credibility and motivations. Victoria's pen pauses over her legal pad for the first time during the proceedings. The three federal agents in the gallery shift almost imperceptibly in their seats, their body language confirming that they're witnessing the critical phase of a complex operation. What kind of irregularities? Judge Whitmore asks, his interest clearly piqued by the possibility of attacking Victoria's character rather than addressing her evidence. Financial instability, Your Honor. A history of employment terminations, eviction proceedings, substantial credit card debt. The kind of pattern that suggests someone who might view a relative's inheritance as an opportunity to solve long-standing monetary problems rather than seeking legitimate justice. The character assassination is expertly delivered, designed not just to question Victoria's legal claims, but to attack her personal integrity, her fitness as a member of society, her worthiness to inherit anything from anyone. It's the kind of class-based warfare that the American legal system enables through unequal access to representation and judicial bias in favor of wealth and status. Furthermore, Thornfield continues, warming to his theme with the enthusiasm of someone who believes he's found the winning argument, I have documentation suggesting that Miss Blackstone was estranged from her aunt for several years prior to Viola's death. We're not talking about a grieving family member seeking rightful inheritance. We're talking about someone who showed up only after discovering the size of the estate. Victoria sets down her pen and rises with fluid grace, her movement carrying the controlled authority of someone who has spent years learning to project calm under extreme pressure. Your Honor, I object to this character assassination masquerading as legal argument. Mr. Thornfield's personal attacks on my financial situation are irrelevant to the legal question of whether my aunt executed her will under undue influence. The witness's credibility is always relevant. Thornfield shoots back with the confidence of someone who has successfully used class prejudice to win cases for decades. The court needs to understand who we're dealing with. Who we're dealing with, Victoria repeats slowly, her voice carrying undertones of steel that few people in the courtroom recognize as the sound of a trap being sprung, is a woman seeking justice for an elderly relative who was exploited by people in positions of trust. If the court wishes to examine credibility, I suggest we focus on the witness who just admitted to committing perjury rather than engaging in speculation about my personal finances. Judge Whitmore pounds his gavel with excessive force, the sound echoing through the courtroom like a gunshot. Miss Blackstone, you will not lecture this court on relevance or procedure. Mr. Thornfield, continue. What follows is 15 minutes of systematic character destruction that would be devastating if Victoria were actually the struggling working-class woman she appears to be. Thornfield produces documents showing her employment at various service industry jobs, waitressing, retail, cleaning services, presenting honest work as evidence of moral deficiency. He presents evidence of late rent payments, credit card debt, and the kind of financial struggles that millions of Americans face daily, but which the legal system treats as disqualifications from justice. Throughout the assault, Victoria maintains her composure with professional detachment that suggests training in withstanding hostile interrogation. She takes notes, documents each attack, and responds to direct questions with concise accuracy. But she doesn't defend herself with the emotional protests that most people would offer under similar circumstances. Instead, she watches, she analyzes, she catalogs every procedural violation, every ethical breach, every moment when Judge Whitmore allows Thornfield to exceed the bounds of legal advocacy and venture into pure character assassination. The three federal agents notice her unusual calm under fire. They notice the way she organizes her notes with tactical precision, the systematic methodology of her documentation, the professional patience of someone who's willing to absorb damage in order to gather evidence of judicial corruption. When Thornfield finishes his attack, Judge Whitmore turns to Victoria with barely concealed satisfaction, believing that he has successfully destroyed her credibility while maintaining plausible deniability about his own bias. Miss Blackstone, do you have any response to counsel's concerns about your motivations and credibility? Victoria stands, straightens her thrift store blazer, and delivers a response that will be quoted in civil rights legal briefs for years to come. Your Honor, Mr. Thornfield's strategy appears to be based on the assumption that poverty disqualifies someone from seeking justice, that working-class employment history constitutes evidence of moral deficiency, that financial struggles somehow invalidate legal claims based on evidence and law. Her voice rises slightly, carrying clearly to every corner of the courtroom with the projection of someone trained to command attention in hostile environments. I reject that premise completely. My aunt's will was executed under circumstances that violated Maryland law. Those circumstances don't change based on my credit score, my employment history, or Mr. Thornfield's opinion of my worthiness to inherit anything. She pauses, letting the words settle into the consciousness of everyone present. If this court believes that justice depends on economic status rather than evidence, then we're not really talking about justice at all. The courtroom falls silent as the fundamental question at the heart of the American legal system hangs in the air. Does justice depend on who you are or on what the evidence shows? Then the moment passes, and Judge Whitmore reasserts his authority with the force of a judicial sledgehammer designed to crush any challenge to his power. Miss Blackstone, you seem to have confused this courtroom with a political rally. We're here to adjudicate legal claims according to established law and procedure. Your philosophical opinions about economic justice are irrelevant to the matter at hand. It's a dismissal designed to humiliate, to put Victoria back in what he considers her proper place in the social hierarchy. But it has an unintended effect. Members of the gallery, particularly those who aren't lawyers or court personnel, begin to see the dynamic for what it really is. A rigged game where outcomes are predetermined by power rather than evidence. Court reporter Sage Millfield continues typing with machine-like precision, but her professional neutrality has cracked as she realizes she's witnessing not just bias, but the systematic denial of equal justice under law. Her stenographic record will become crucial evidence in the federal civil rights investigation that's about to explode into public view. Bailiff Camden Ross shifts uncomfortably in his position near the bench. He's worked this courtroom long enough to recognize when proceedings cross the line from legitimate judicial authority into something darker and more dangerous. Even some of the lawyers in the gallery begin exchanging concerned glances. Whatever they think of pro se litigants generally, what's happening to Victoria Blackstone violates the professional standards they swore to uphold when they took their oath as officers of the court. The professional escalation continues when Judge Whitmore abandons any pretense of judicial neutrality and launches a direct assault on Victoria's right to represent herself. Miss Blackstone, I'm going to ask you one final time. Are you absolutely certain you want to proceed without qualified legal representation? Because I'm beginning to think that your current approach is not serving your interests or the interests of judicial efficiency. I'm prepared to proceed, Your Honor. Very well, but understand that this court will not lower its standards of professional presentation simply because you've chosen to represent yourself. If you cannot meet the procedural requirements expected of qualified counsel, you will face the consequences. Translation: I'm going to hold you to impossible standards and rule against you when you inevitably fail to meet them. But Victoria Blackstone has spent 18 months preparing for exactly this moment, Every procedural rule, every evidentiary standard, every appellate court decision has been studied, memorized, and wargamed with the kind of methodical preparation that only comes from federal training protocols and unlimited investigative resources. I understand, Your Honor. Thornfield calls his next witness, Dr. Harrison Wells, a supposed medical expert who claims to have examined Viola Mae Blackstone's mental capacity in the months before her death. Wells presents impressive credentials, speaks with authoritative confidence, and delivers testimony that appears to demolish Victoria's claims of undue influence with scientific precision and professional authority. There's only one problem with Dr. Wells's compelling expert testimony. He never actually examined Viola Mae Blackstone. In fact, on the day he claims to have conducted his evaluation, he was 3,000 miles away on a Disney World vacation with his family. Victoria's cross-examination begins with surgical precision that demonstrates preparation far beyond what any reasonable person would expect from a pro se litigant. Dr. Wells, you testified that you conducted a comprehensive mental capacity evaluation of my aunt on June 30th, correct? That's correct. And this evaluation took place at your office on Vermont Avenue in Northwest Washington? Yes. For approximately how long? 90 minutes. Standard protocol for cognitive assessment includes multiple evaluation tools, memory testing, and behavioral observation. I see. Dr. Wells, I'm showing you what's been marked as Plaintiff's Exhibit 16. Can you identify this document? Wells examines the paper with growing unease, his confident demeanor beginning to crack as he recognizes the implications of official financial records. It appears to be some kind of credit card statement. Specifically, it's your personal credit card statement from June of this year. Can you locate the entry for June 30th? Wells scans the document, his face growing pale as he realizes he's walking into a trap that has been months in preparation. I see several charges. Can you read the location and timestamp for the charge at Hertz Rental Car, please? Orlando International Airport, June 30th, 2:23 p.m. And the charge at Disney's Grand Floridian Resort? Wells's voice becomes barely audible. Same date, 6:37 p.m. So according to your own credit card records, you were in Orlando, Florida, on the day you claim to have examined my aunt in your Washington office. The courtroom erupts again, but this time the whispers carry a different tone. Members of the gallery are beginning to understand that they're witnessing systematic perjury, not isolated mistakes or memory lapses. Thornfield objects frantically, but the evidence is devastating and undeniable. Wells has been caught in an obvious lie, his expert testimony revealed as pure fabrication designed to support a predetermined conclusion. Your Honor, Victoria continues with relentless calm that speaks to years of experience in hostile interrogation environments, I have additional exhibits showing Dr. Wells's hotel reservations, airline tickets, theme park admissions, and restaurant charges for a week-long vacation in Florida. Unless he's developed the ability to be in two places simultaneously, his testimony is false. Judge Whitmore's face has transformed from judicial authority to barely controlled rage, as he realizes that what should have been a simple inheritance dispute has become a cascade of perjury, fraud, and professional misconduct that threatens to expose the entire corrupt network he's spent years building and protecting. Dr. Wells, the judge asks desperately, his voice carrying the strain of someone watching carefully laid plans collapse in real time. Can you explain this apparent discrepancy? Wells opens and closes his mouth like a fish drowning in air. There is no explanation that can reconcile his testimony with documented evidence of his whereabouts. The credit card records, hotel reservations, and travel documentation create an unbreakable chain of proof that destroys his credibility completely. I may have been mistaken about the dates. Mistaken about traveling to Florida for vacation? Victoria's voice carries the weight of prosecutorial authority that silences the courtroom. Dr. Wells, did you ever meet my aunt? I need to consult my records. Did you ever speak with her? I would need to review. Did you ever examine her mental capacity in any capacity whatsoever? Silence stretches through the courtroom like a taut wire about to snap. Dr. Wells, please answer the question. No. The word comes out as a whisper that carries the weight of complete professional destruction. No, I never met her. Want to understand the law like our secret agent? Masterclass offers courses taught by legal experts and FBI professionals. Learn negotiation tactics, constitutional law, and investigative techniques from the world's best instructors. With unlimited access to over 180 classes, you can master new skills at your own pace. Visit masterclass.com/knowledge and get 15% off your annual membership. Knowledge is power, especially when it's expert knowledge. Judge Whitmore calls for an emergency recess, but the damage is irreversible and the pattern of fraud has become impossible to ignore or dismiss. 2 witnesses have now committed perjury in his courtroom, both in service of Thornfield's client, both exposed through investigation that suggests resources far beyond what a struggling working-class woman should be able to access. In chambers, panic sets in as the carefully constructed corruption network begins to collapse under scrutiny that was never supposed to occur. "This is a complete disaster," Thornfield hisses with the desperation of someone watching his career implode in real time. "She's destroying our case piece by piece. Every witness, every piece of evidence. She has answers for everything. How is she getting this information?" Judge Whitmore demands, his voice carrying the strain of someone who has built his life on corruption and is watching it all fall apart. "Credit card records, travel documents, security footage. Normal people don't have access to this kind of intelligence gathering capability. I don't know, but we need to shut this down immediately. Declare a mistrial, cite procedural irregularities, claim prejudicial publicity, anything to stop this before it goes any further." On what grounds? Her evidence is legitimate. Her procedures are flawless. If I rule against her now without legal justification, we'll have appellate court scrutiny, media attention, federal oversight. Then what do you suggest? Judge Whitmore's next decision will define the rest of his life, though he doesn't know it yet. Faced with the choice between admitting systemic corruption and doubling down on abuse of power, he chooses escalation, a decision that will provide federal agents with the final evidence they need for criminal prosecution. When court reconvenes, his mask of judicial neutrality has been replaced by open hostility that violates every principle of due process and equal justice under law. "Miss Blackstone, this court is deeply troubled by the irregularities in this proceeding. While your evidence may be technically admissible, the manner in which you've obtained these records raises serious questions about unauthorized investigation, potential harassment of witnesses, and possible violations of privacy law. It's a desperate attempt to flip the script, to make Victoria's competence evidence of wrongdoing rather than preparation, to criminalize effective legal advocacy when it threatens corrupt authority. Your Honor," Victoria responds with devastating calm that speaks to years of training in managing hostile situations. "Every document I've presented was obtained through legal means. Public records requests, properly served subpoenas, and lawfully available information. If the court has concerns about specific evidence, I respectfully request identification of the alleged procedural violations." Judge Whitmore realizes he's trapped again. Victoria's investigative methods have been entirely legal. To exclude evidence obtained through proper channels would constitute reversible error on appeal and could trigger federal civil rights investigation. So he tries a different approach, abandoning any pretense of legal authority for naked intimidation. "Miss Blackstone, this court finds your level of preparation unusual for a pro se litigant. I'm ordering a recess to allow the court to investigate the possibility of undisclosed assistance in preparation of your case." "Your Honor," Victoria stands with fluid grace, her response delivered with the quiet authority of someone who understands constitutional law better than the judge questioning her. "I respectfully object. The court lacks authority to investigate plaintiff's case preparation in the absence of specific evidence of procedural violations. To do so would violate my right to counsel, or in this case, my right to self-representation under the 6th and 14th Amendments. Miss Blackstone, you will not lecture this court on its authority." Judge Whitmore's voice explodes through the courtroom with thunderous intensity that makes members of the gallery flinch and court personnel look uncomfortable. Even Thornfield appears surprised by the vehemence of the judicial outburst, recognizing that his ally has crossed the line from bias into open judicial tyranny. "Your Honor," Victoria responds without raising her voice, her calm delivery contrasting sharply with the judge's emotional outburst. "I'm merely citing established precedent. In Ferretta versus California, the Supreme Court held that—" "I don't care what the Supreme Court held," Whitmore explodes, abandoning any pretense of judicial temperament. "This is my courtroom, and you will follow my procedures or face contempt charges." The moment hangs suspended like a sword over the entire proceeding. Everyone present understands that they've just witnessed judicial temperament collapse into judicial tyranny. Judge Whitmore has abandoned any pretense of legal authority and revealed the personal animus driving his decisions. Court reporter Sage Millfield types every word with mechanical precision, creating a permanent record of judicial misconduct that will survive long after the immediate crisis passes and become evidence in federal criminal proceedings. The 3 federal agents exchange the slightest of glances, their silent communication confirming that the target has just provided enough evidence for criminal charges under Title 18, United States Code, Section 242, deprivation of civil rights under color of law, but they remain motionless, waiting for their undercover agent to complete her mission and provide the final evidence necessary to destroy the entire corrupt network. Victoria Blackstone stands at the plaintiff's table, surrounded by hostile legal authority, facing a corrupt judge who has abandoned any pretense of impartiality, opposed by lawyers who have built their careers on systematically denying justice to anyone without wealth and connections. The deck is stacked, the game is rigged, and the entire system seems designed to crush anyone who dares to challenge established power. She should be terrified. She should be intimidated. She should accept whatever settlement is offered and retreat from a battle she cannot win against opponents with unlimited resources and institutional authority. Instead, she straightens her shoulders, meets Judge Whitmore's glare with steady eyes that hold depths he cannot fathom, and speaks words that will echo through the federal courts for years to come. Your Honor, if this court believes that my legal preparation is somehow evidence of wrongdoing, then perhaps the problem isn't with my preparation. Perhaps the problem is with a system that expects citizens to fail when they seek justice. The silence that follows is profound and dangerous. Judge Whitmore's face turns purple with rage. Thornfield looks like he's witnessing a train wreck in slow motion. Members of the gallery hold their breath, sensing that they're about to witness either an extraordinary triumph or complete destruction. The transformation begins with a phone call that will change everything. Agent Morrison, having exited the courtroom during Victoria's defiant speech, speaks into his encrypted device with the calm authority of someone who has been waiting 18 months for this moment. Blackwood, this is Morrison. Target has achieved maximum exposure. Judicial misconduct is now documented beyond any reasonable doubt. Request authorization for federal intervention. 3 blocks away, in a nondescript office building that houses one of the FBI's most sensitive operations, Special Agent in Charge Diana Blackwood reviews the accumulated evidence on multiple computer screens. Bank records showing suspicious transfers. Audio recordings of judicial conversations that should never have occurred. Surveillance footage documenting meetings that violate every ethical standard of judicial conduct. Operation Fallen Shield has documented a corruption network that extends far beyond a single biased judge. What began as an investigation into judicial misconduct has uncovered systematic civil rights violations, racketeering activities, and abuse of power that threatens the fundamental integrity of the legal system. Authorization granted. Initiate federal takeover protocol. And Morrison, tell our agent she's done extraordinary work. The evidence package she's assembled will reform judicial oversight for decades. Back in courtroom 4A, the tension has reached a breaking point that threatens to shatter the carefully maintained facade of legal proceedings. Judge Whitmore glares at Victoria with undisguised hatred while she organizes her evidence with professional calm that suggests resources far beyond what any reasonable person should possess. Neither realizes that federal agents are already positioning themselves throughout the building, that U.S. attorneys are reviewing indictments that have been months in preparation, that the entire corrupt network they've built is about to collapse under the weight of federal law enforcement. Miss Blackstone, Judge Whitmore says with forced judicial authority that can no longer conceal his panic, I've heard enough of your philosophical lectures. This court operates according to established legal principles, not social justice rhetoric. Your Honor, Victoria responds with devastating precision that cuts through his bluster like a surgical instrument. I believe the established legal principle is equal justice under law. Perhaps we could focus on that constitutional requirement. It's another masterful response that sounds respectful while being profoundly subversive. She's calling attention to the fundamental promise of American justice while highlighting how far this courtroom has strayed from that ideal. Judge Whitmore pounds his gavel with excessive force that echoes through the courtroom like the sound of his own career ending. Miss Blackstone, you are in contempt of court. Bailiff, escort this woman to the holding cell until she learns proper respect for judicial authority. The order is illegal, vindictive, and professionally suicidal. Contempt of court requires specific procedural violations, not disagreement with judicial opinions. Judge Whitmore has just demonstrated that his decisions are based on personal animus rather than legal authority, and he's done it in front of witnesses whose testimony will destroy him. But Camden Ross, the bailiff, doesn't move toward Victoria's table. Instead, he reaches for his radio and speaks words that will end Judge Whitmore's career. This is Bailiff Ross requesting immediate assistance in courtroom 4A. We have a situation requiring federal intervention. The words hang in the air like a death sentence. Judge Whitmore's face goes white as he realizes that his own bailiff has just called for help against him rather than following his illegal orders. Ross, what are you doing? I gave you a direct order. Camden Ross has worked this courtroom for 15 years. He's watched Judge Whitmore bend rules, ignore evidence, and favor connected parties over justice. But what he's witnessed today crosses every line of professional ethics and legal authority. More importantly, he's seen enough federal investigations to recognize one when it's happening in his own courtroom. Your Honor, Ross says with quiet dignity that speaks to 23 years of military service before his courthouse career. I swore an oath to support and defend the Constitution of the United States. I will not participate in the violation of a citizen's civil rights. The courtroom erupts in chaos as members of the gallery begin talking, shouting, recording with their phones despite court rules prohibiting such behavior. Thornfield looks like he's about to vomit as he realizes that his carefully constructed case has become a federal crime scene. Court reporter Sage Millfield continues typing with mechanical precision, creating a permanent record of judicial authority in complete collapse. Through it all, Victoria Blackstone remains seated at the plaintiff's table, organizing her files with the same professional calm she's maintained throughout the hearing. To an untrained observer, she looks like someone who's accepted defeat with admirable grace. To the federal agents watching her, she looks like someone who's successfully completed one of the most complex undercover operations in FBI history. The courtroom doors open with the authority of federal law enforcement. Agent Morrison enters first, followed by 3 other men whose bearing and dress immediately identify them as federal agents. They don't announce themselves or flash badges. Their presence speaks for itself with the kind of quiet authority that comes from unlimited federal resources and constitutional mandate. Ladies and gentlemen, Morrison says with calm authority that cuts through the courtroom chaos. This courtroom is now under federal oversight pending resolution of an ongoing civil rights investigation. Judge Whitmore's world begins collapsing in real time as he realizes that his threats and intimidation have been observed, documented, and recorded by federal agents with the power to destroy everything he's built over 2 decades of corrupt judicial service. What investigation? What authority do you have to? Morrison produces a leather wallet, flipping it open to reveal the golden shield of federal law enforcement. Agent Morrison, Federal Bureau of Investigation. We're here pursuant to an ongoing civil rights investigation under Title 18, United States Code Section 242. The federal statute criminalizes the denial of constitutional rights under color of law. In plain English, it's illegal for government officials to abuse their power to violate citizens' civil rights. Judge Whitmore has just provided 18 months' worth of evidence that he's been doing exactly that. This is outrageous! Thornfield attempts to assert some control over the rapidly deteriorating situation, his voice carrying the strain of someone watching a lifetime of careful planning collapse in minutes. You can't just storm into a courtroom during ongoing proceedings. There are procedures, protocols. Mr. Thornfield, Agent Morrison says with devastating calm that silences all protest. I suggest you contact your attorney immediately. You're going to need one. The words carry the weight of impending criminal charges that everyone present understands. What began as a civil inheritance dispute has become a federal criminal investigation with the power to send people to prison for decades. Victoria rises from her table and approaches Agent Morrison with the confident stride of someone who knows exactly what's happening and has been preparing for this moment for over a year. Agent Morrison, she says with professional recognition that surprises everyone except the federal agents, I believe you have some documents for the court's review. Morrison hands her a thick folder marked with federal evidence seals and classification stamps. As she opens it, Judge Whitmore finally begins to understand the magnitude of his situation and the sophisticated nature of the trap that has been closing around him for months. Ladies and gentlemen, Victoria announces to the courtroom with the authoritative projection of someone accustomed to addressing federal prosecutors and congressional committees, I'm presenting Federal Exhibits 1 through 37, audio recordings, financial documents, surveillance footage, and telecommunications intercepts documenting a pattern of judicial corruption spanning 47 cases over the past 18 months. The words hit the courtroom like a physical blow that leaves everyone stunned into silence. Judge Whitmore's mouth opens and closes soundlessly as he processes the implications of federal surveillance. Thornfield begins backing toward the exit only to find federal agents positioned at every door. Members of the gallery lean forward, realizing they're witnessing legal history in the making. Furthermore, Victoria continues with prosecutorial authority that transforms her from apparent victim into federal law enforcement officer. I'm submitting authentication from the Federal Bureau of Investigation's Forensic Accounting Division, confirming that Judge Whitmore received over $300,000 in payments from entities connected to Thornfield Hayes and Associates. Judge Whitmore finds his voice long enough to issue a desperate denial that fools no one. This is impossible. I've never taken money from anyone. These allegations are fabricated. Federal Exhibit 12, Victoria interrupts smoothly, producing a document that represents months of financial investigation. Bank transfer documentation showing payments from Thornfield Holdings, LLC to Whitmore Consulting Services. Federal Exhibit 13, incorporation documents showing that Whitmore Consulting Services lists Judge Cornelius Whitmore as its sole proprietor and beneficiary. The evidence trail is devastating in its clarity and precision. Judge Whitmore created a shell company to receive bribes, thinking that one layer of corporate protection would hide his corruption from federal scrutiny. What he didn't realize is that federal agents have investigative tools and resources far beyond local law enforcement capabilities, including the ability to trace financial transactions through multiple jurisdictions and corporate entities. Federal Exhibit 14, Victoria continues with relentless precision that speaks to months of careful preparation. Wiretap recordings authorized under Federal Intelligence Surveillance Act, warrant number 7894, documenting conversations between Judge Whitmore, Maxwell Thornfield, and Deputy Clerk Sloan Aldrich regarding case fixing, evidence suppression, and witness intimidation. The words wiretap recordings electrify the courtroom as everyone present understands that federal agents have been listening to private conversations, documenting criminal conspiracy with the precision of a comprehensive RICO investigation. Judge Whitmore's face transforms from judicial authority to pure panic as he realizes the scope of federal surveillance. You've been recording my conversations? That's illegal surveillance. You need warrants, court authorization. Agent Morrison produces another document from his briefcase with the calm efficiency of someone who has anticipated every possible challenge to their investigation. FISA Warrant 7894, authorized by Federal District Judge Patricia Chen, Eastern District of Maryland. Surveillance authority granted due to credible evidence of ongoing civil rights violations and systematic judicial corruption. The legal framework clicks into place like pieces of a sophisticated puzzle that has been 18 months in construction. This isn't a rogue investigation or prosecutorial overreach. Federal agents have been building a case with methodical precision, using every legal tool available to gather evidence of systematic corruption that threatens the constitutional foundation of equal justice under law. Sage Millfield continues typing with machine-like accuracy, creating a stenographic record that will become evidence in criminal trials spanning multiple jurisdictions and potentially reaching the federal appellate courts. Her professional neutrality has evolved into something approaching awe as she witnesses the complete exposure of corruption she's suspected for years but never had the power to challenge. Wait, did she just quote federal statute from memory? Who is this woman? The judge looks confused, the lawyers are scrambling, and I'm getting chills. Something major is about to drop. If you're on the edge of your seat like I am, hit that notification bell because you won't want to miss what's coming. The cascade of evidence continues with devastating precision that leaves no room for denial or rationalization. Audio recordings reveal conversations where Judge Whitmore discusses case outcomes before hearing evidence, violating every principle of judicial impartiality. Financial documents show payments timed to coincide with favorable rulings, establishing a clear pattern of quid pro quo corruption. Surveillance footage captures meetings between supposedly impartial judicial officials and interested parties, documenting the systematic nature of the conspiracy. Federal Exhibit 18, Victoria announces with the authority of someone reading an indictment, documentation showing that Deputy Clerk Sloan Aldrich received $60,000 for altering filing dates, losing critical documents, and providing advance notice of court schedules to Thornfield's firm. Sloan Aldrich, who has been watching the proceedings from her clerk's station with growing horror, finally breaks under the weight of federal evidence and the prospect of decades in prison. "I want immunity," she shouts from across the courtroom, her voice carrying the desperation of someone who realizes that cooperation is her only hope for avoiding complete destruction. "I want to cooperate. I can give you everything: bank accounts, phone records, meeting locations, names of everyone involved. I never wanted to be part of this." Her desperate confession confirms what federal agents have suspected. The corruption extends beyond individual bad actors into systematic institutional failure that requires comprehensive federal intervention. Court personnel, elected officials, and legal professionals have created a network designed to deny justice to anyone without money, connections, or political power. Judge Whitmore makes one final desperate attempt to assert judicial authority that no longer exists. This court does not recognize federal jurisdiction over state inheritance proceedings. "You have no authority to interfere with—" "Your Honor," Victoria interrupts with the voice of someone accustomed to command and constitutional authority. "Federal jurisdiction is triggered by civil rights violations under color of state law. When state judicial officials deny equal protection and due process, federal oversight becomes not just authorized but constitutionally mandatory under the 14th Amendment and federal civil rights statutes. The constitutional law is clear, undeniable, and supported by decades of federal court precedent. State courts operate under federal constitutional constraints, and when those constraints are violated, federal agents have both the authority and the obligation to intervene to protect constitutional rights. Judge Whitmore's last shield of legal protection has been stripped away, leaving him exposed to the full weight of federal criminal prosecution and the possibility of decades in federal prison. Federal Exhibit 23 Victoria continues with relentless precision that demonstrates the comprehensive nature of the federal investigation. Documentation showing that Thornfield, Hayes & Associates has systematically bribed court personnel in 47 cases over 18 months, resulting in fraudulent judgments totaling over $12 million. Maxwell Thornfield makes a desperate attempt to flee the courtroom, but Agent Morrison's colleagues have positioned themselves at every exit with the tactical precision of a planned federal arrest operation. There is no escape from federal jurisdiction once it's been properly triggered and documented. "Mr. Thornfield," Morrison calls across the courtroom with calm authority, "please remain seated. We have some questions for you." The words carry the weight of impending arrest and federal prosecution. Thornfield collapses back into his chair, his expensive suit suddenly looking like a costume that no longer fits the role he's been playing for decades. The evidence presentation reaches its climax when Victoria produces the final exhibit that will become the cornerstone of federal prosecution, a comprehensive analysis of judicial bias that demonstrates systematic discrimination based on race, class, and political affiliation. "Federal Exhibit 27, she announces to the silent courtroom, "statistical analysis prepared by the Federal Bureau of Investigation's Behavioral Analysis Unit, documenting systematic racial bias in judicial decision-making that violates both the Equal Protection Clause of the 14th Amendment and federal civil rights statutes." The numbers are devastating because they're objective, mathematical, and impossible to explain as coincidence or individual prejudice. When judicial decisions correlate with racial demographics rather than legal evidence, when outcomes depend on defendants' economic status rather than factual guilt or innocence, the statistical pattern becomes evidence of intentional discrimination that violates the most fundamental principles of American justice. Judge Whitmore sits behind his bench in stunned silence, watching 18 months of careful federal investigation destroy everything he's built over 2 decades of judicial service. His reputation, his career, his freedom, his financial security, all collapsing under the weight of evidence he never knew was being gathered by federal agents with resources and legal authority that dwarf any state-level investigation. The 3 federal agents in the gallery have remained motionless throughout the revelation, but now they rise in unison and approach the bench. Their movement carries the ceremonial gravity of federal justice finally asserting itself over state-level corruption, the constitutional principle of equal protection under law overriding local political networks and financial influence. Agent Morrison speaks with the authority of federal law enforcement and constitutional mandate. "Judge Whitmore, you're under investigation for violations of Title 18, United States Code Sections 241 and 242, conspiracy against civil rights and deprivation of civil rights under color of law. You have the right to remain silent. You have the right to legal representation. Any statements you make may be used against you in federal court." The Miranda warnings echo through the courtroom with historic weight, as members of the gallery understand that they're witnessing the federal arrest of a sitting judge for civil rights violations, an event that occurs perhaps once in a generation, and that will reshape local legal culture for decades. But the most extraordinary revelation is yet to come, and it will transform everyone's understanding of the woman who walked into this courtroom with the apparent goal of challenging a simple inheritance dispute. Victoria Blackstone approaches the bench with measured steps that carry the authority of someone who has been building toward this moment for 18 months of careful preparation and federal investigation. Every procedural violation, every ethical breach, every moment of bias has been documented with federal precision and transmitted to prosecutors who are already preparing criminal indictments. She reaches into her briefcase one final time, her movement watched by everyone in the courtroom, federal agents who know what's coming, court personnel who suspect something extraordinary is happening, gallery members who sense they're witnessing history, and corrupt officials who are about to discover they've been playing a game whose rules they never understood. When she withdraws her hand, she's holding a leather wallet that she opens with practiced precision and professional authority. Inside, gleaming against black leather with the full power of federal law enforcement, is the golden badge of the Federal Bureau of Investigation, The badge that transforms everything everyone thought they knew about the woman who walked into this courtroom. The badge that reveals 18 months of deep undercover investigation. The badge that explains how a supposed working-class waitress obtained classified financial records, surveillance footage, expert testimony, and investigative resources that would be impossible for any civilian to access. The badge of Special Agent Victoria Blackstone, Federal Bureau of Investigation, Civil Rights Division. The silence that follows is profound and complete. Even the steady clicking of Sage Millfield's stenographic machine stops as she stares in shock at the federal credentials that explain everything she's witnessed over the past 3 hours. Judge Whitmore's face goes white as paper. His mouth opens and closes silently as his brain struggles to process the implications of what he's seeing. The woman he's been bullying, intimidating, and threatening is a federal agent who has been gathering evidence of his crimes with the full authority of the United States government. Maxwell Thornfield makes a strangled sound that might be laughter or despair as he realizes that every conversation, every strategic meeting, every corrupt scheme has been observed and documented by someone with the power to destroy him completely. "Ladies and gentlemen," Victoria announces to the stunned courtroom, her voice carrying the full authority of federal law enforcement, Special Agent Victoria Blackstone, Federal Bureau of Investigation, Civil Rights Division. For the past 18 months, I have been conducting an undercover investigation into systematic corruption within the Montgomery County judicial system as part of Operation Fallen Shield. The courtroom erupts in chaos as reporters rush for the doors, gallery members shout questions, and court personnel struggle to process what they're witnessing. The revelation explains everything: the sophisticated legal arguments, the access to classified records, the investigative resources that seemed impossible for a pro se litigant to possess. "Your Honor," Victoria continues, addressing Judge Whitmore with the cold professionalism of a federal agent reading charges, "you are under arrest for violations of Title 18, United States Code, Section 242, deprivation of civil rights under color of law. Title 18, Section 241, conspiracy against rights. Title 18, Section 1341, racketeering activities, and multiple counts of bribery, fraud, and obstruction of justice. The federal charges carry potential sentences of decades in prison. Judge Whitmore's corruption isn't just an ethical violation or a professional mistake. It's a systematic attack on constitutional rights that threatens the foundation of American justice." Federal marshals enter the courtroom with the precision of a planned arrest operation, their presence confirming that today's revelation has been months in preparation. They approach the bench with handcuffs and federal arrest warrants that have been waiting for exactly this moment. "Judge Cornelius Whitmore," the lead marshal announces, "you are under arrest. You have the right to remain silent. Anything you say can and will be used against you in a court of law." Judge Whitmore's judicial robes, symbol of authority and impartial justice, suddenly look like a costume as federal agents strip away the pretense of legitimacy that has protected his crimes for years. He offers no resistance as handcuffs click around his wrists, the same hands that signed fraudulent orders and accepted bribes disguised as consulting fees. "This can't be happening. He's good as something," he whispers, but his voice carries no conviction. The evidence is overwhelming, the federal authority undeniable, and his crimes documented with precision that will survive every appeal and legal challenge. Maxwell Thornfield attempts to assert attorney-client privilege, claiming he was just representing his client's interests and had no knowledge of judicial corruption. But Victoria produces Federal Exhibit 38, audio recordings of Thornfield explicitly discussing bribery amounts, case outcomes, and strategies for avoiding detection. "Mr. Thornfield," she says with prosecutorial authority, "you are also under arrest for conspiracy, bribery of public officials, racketeering, and fraud. Your law firm has been systematically corrupting the judicial process for financial gain, denying constitutional rights to dozens of citizens who trusted the system to provide equal justice." Federal agents move through the courtroom with military precision, arresting Sloan Aldrich despite her desperate offers to cooperate, seizing documents that have been prepared for months, and implementing a federal takeover that will reshape the local legal system for decades to come. Furthermore, Victoria announces to the packed courtroom, this investigation has uncovered evidence of similar corruption in 3 additional Maryland counties, resulting in federal oversight of judicial operations and the largest civil rights investigation in the state's history. The scope of Operation Fallen Shield extends far beyond a single corrupt judge. Federal agents have documented systematic discrimination, bribery networks, and constitutional violations that require comprehensive federal intervention to protect citizens' rights. Special Agent in Charge. Diana Blackwood enters the courtroom flanked by federal prosecutors and Justice Department officials. Her presence confirms the national significance of the investigation and the federal government's commitment to restoring constitutional protections that have been systematically violated. Agent Blackstone, SAC Blackwood says with obvious pride, "Outstanding work. Your investigation has provided the Justice Department with sufficient evidence to prosecute one of the most comprehensive judicial corruption cases in federal history." The commendation acknowledges 18 months of dangerous undercover work that required Victoria to maintain her false identity while gathering evidence that could have resulted in her death if discovered by corrupt officials with unlimited local political power. Court reporter Sage Millfield, still typing despite the chaos around her, realizes that her stenographic record has become evidence in a federal criminal case that will be studied in law schools for decades. Her documentation of judicial misconduct will help ensure that constitutional violations are never dismissed as mere procedural irregularities. Bailiff Camden Ross, whose refusal to follow illegal orders triggered the final phase of federal intervention, receives recognition from federal officials for his commitment to constitutional principles over personal loyalty to corrupt authority. Ladies and gentlemen, Victoria addresses the courtroom for the final time in her undercover role. The inheritance dispute that brought me here today was real. Viola Mae Blackstone was my aunt, and she was indeed exploited by those who were supposed to protect her. But justice for her, and for dozens of other victims, required more than a simple civil lawsuit. It required federal intervention to restore constitutional protections that had been systematically destroyed by corruption. The personal motivation behind her investigation adds emotional weight to the federal charges. Victoria wasn't just a federal agent doing her job. She was a niece seeking justice for family while protecting the constitutional rights of complete strangers who deserved better from their legal system. The aftermath of Operation Fallen Shield unfolds with the systematic precision of federal law enforcement backed by unlimited resources and constitutional authority. Within hours of the arrests, federal teams execute search warrants across 3 counties, seizing financial records, computer files, and communications that document the full scope of the corruption network. Judge Cornelius Whitmore, stripped of his judicial authority and facing federal charges that could result in life imprisonment, sits in federal custody while his expensive home is searched by agents who find additional evidence hidden behind books and inside specially constructed compartments. His judicial pension is frozen, his assets seized, and his political connections severed by the scandal. Maxwell Thornfield's law firm collapses within days as clients flee, partners attempt to distance themselves from the investigation, and federal agents uncover evidence of systematic fraud extending back over a decade. The firm's bank accounts are frozen, their client files subpoenaed, and their professional licenses suspended pending the outcome of federal prosecution. But the most significant impact is the institutional reform that follows federal intervention. The Maryland judicial system implements new oversight procedures, mandatory bias training, and federal monitoring that will continue for years to ensure constitutional compliance. Victoria Blackstone, her undercover assignment completed, returns to FBI headquarters in Washington where she briefs congressional committees on judicial corruption and helps develop federal guidelines for preventing similar constitutional violations. Her testimony leads to legislative reforms that strengthen federal oversight of state courts and expand civil rights protections for vulnerable populations. The inheritance case that began the investigation is quickly resolved in Victoria's favor, with federal oversight ensuring that the original will reflects Viola Mae Blackstone's true intentions rather than the manipulated document prepared by corrupt lawyers. The $2.3 million estate goes to fund a legal aid foundation that provides representation for people who cannot afford attorneys. That badge drop was legendary, but this isn't the only time someone's hidden identity completely destroyed their enemies. Next week, I'm covering a story about a homeless man who walked into a corporate boardroom. You won't believe what happened when they found out who he really was. Stay tuned. 6 months later, federal trials begin with Victoria testifying as the key witness in proceedings that attract national media attention. Her 18 months of undercover work provide prosecutors with an unprecedented documentary record of judicial corruption that results in convictions for everyone involved. Judge Whitmore receives a 25-year federal sentence after being convicted on all charges. His judicial career ends in disgrace, his reputation destroyed, and his freedom forfeit to federal prison, where he will spend the remainder of his natural life. Maxwell Thornfield accepts a plea agreement that requires him to cooperate with ongoing federal investigations in exchange for a reduced sentence of 15 years. His cooperation exposes additional corruption in neighboring states, leading to more federal prosecutions and institutional reforms. Sloan Aldrich, whose desperate offer to cooperate saves her from the harshest penalties, receives 7 years in federal prison after providing crucial testimony that helps convict higher-ranking conspirators. Her cooperation reveals the systematic nature of the corruption and helps federal agents identify similar problems in other jurisdictions. The federal investigation continues as agents follow financial trails and communication networks that extend beyond Maryland into federal judicial circuits. What began as a single inheritance dispute has uncovered systematic constitutional violations that require ongoing federal oversight to prevent future abuses. Victoria's work on Operation Fallen Shield leads to her promotion within the FBI's Civil Rights Division and assignment to develop new undercover protocols for investigating judicial corruption. Her methods become a model for federal agents working similar cases across the country. But the victory is not complete. Institutional corruption of this magnitude cannot be eliminated through arrests and convictions alone. The cultural changes necessary to ensure equal justice under law require decades of vigilance, ongoing federal oversight, and constant pressure from citizens who refuse to accept discrimination as normal. The Legal Aid Foundation, established with Viola Mae Blackstone's inheritance, provides representation for hundreds of people who would otherwise be denied justice by an unequal system. Their cases continue to expose bias, challenge discrimination, and slowly expand constitutional protections for all citizens. Court reporter Sage Millfield, whose stenographic record became crucial evidence in federal prosecutions, receives national recognition for her commitment to documenting truth even when it threatens powerful interests. Her work inspires other court personnel to report misconduct and help maintain judicial integrity. Bailiff Camden Ross, whose refusal to follow illegal orders triggered federal intervention, becomes a symbol of constitutional duty prevailing over personal loyalty. His military background and commitment to constitutional principles help other law enforcement officials understand their obligation to protect citizens' rights even when ordered to violate them by corrupt authority. The systemic changes resulting from Operation Fallen Shield extend beyond Maryland as other states implement similar oversight procedures and federal officials expand their monitoring of judicial systems nationwide. The case becomes a landmark precedent for federal intervention when constitutional rights are systematically violated by state judicial authority. Yet significant challenges remain. The corruption exposed by Victoria's investigation was decades in development and will require years of sustained effort to completely eliminate. Federal oversight helps, but lasting change requires cultural transformation within legal communities that have become accustomed to discrimination and bias. The 3 counties subjected to federal monitoring show measurable improvement in judicial decision-making, with statistical analysis documenting more equitable treatment across racial and economic lines. But progress is gradual, and federal agents continue investigating reports of ongoing constitutional violations. Victoria's undercover work reveals the extraordinary measures necessary to document judicial corruption when local political networks protect bad actors and intimidate witnesses. Her investigation required federal resources, sophisticated surveillance technology, and 18 months of dangerous undercover work that could have resulted in her death if discovered by corrupt officials. The constitutional principles at stake, equal protection under law, due process, and equal access to justice, require constant vigilance to maintain. Operation Fallen Shield demonstrates that even fundamental rights can be systematically violated when corruption goes unchallenged and federal oversight is absent. The financial cost of the investigation exceeds $5 million, but the constitutional protections restored are priceless. Dozens of wrongfully convicted citizens receive new trials, hundreds of biased decisions are overturned, and thousands of future victims are protected by the institutional reforms implemented. The political implications extend beyond the Maryland judicial system as federal officials use the investigation to advocate for expanded civil rights enforcement and increased funding for judicial oversight. The case becomes ammunition for reformers seeking to strengthen federal protection of constitutional rights. But perhaps the most important outcome is the message sent to corrupt officials throughout the American legal system. Federal agents are watching, constitutional violations will be prosecuted, and the full power of the federal government will be used to protect citizens' rights when state and local authorities fail to do so. The final chapter of Operation Fallen Shield remains unwritten as federal agents continue investigating similar corruption in other states, as reformed institutions slowly rebuild public trust, and as citizens like Victoria Blackstone work to ensure that equal justice under law is more than just words carved in marble above courthouse doors. 6 months after the arrests, Victoria receives a classified briefing about judicial corruption investigations in federal circuits. suggesting that the problems exposed in Maryland extend to the highest levels of the American legal system. Her next assignment will be even more dangerous, more complex, and potentially more significant for constitutional protections. The phone call comes on a Tuesday morning as she reviews case files in her FBI office overlooking the Potomac River. The voice on the secure line carries the authority of the Justice Department's highest levels. "Agent Blackstone, we have a situation. There's evidence of systematic corruption in federal appellate courts. We need someone with your experience in judicial investigations. How soon can you be in Washington for briefing?" Victoria looks out the window at the federal courthouse where some of the most important constitutional cases in American history have been decided. If corruption has infected federal judicial circuits, the threat to constitutional rights extends far beyond state courts and local political networks. "I can be there this afternoon," she responds, already mentally preparing for another long-term undercover assignment that will test every skill she's developed as a federal agent and constitutional protector. The investigation that began with an inheritance dispute in Montgomery County, Maryland, has exposed systematic threats to constitutional rights that require ongoing federal vigilance to address. Victoria's next assignment will determine whether the principles of equal justice under law can survive in the highest courts of the American legal system. Operation Fallen Shield ends, but the work of protecting constitutional rights continues. In a democracy, the price of freedom is indeed eternal vigilance. And federal agents like Victoria Blackstone are the guardians who ensure that price is paid by those who threaten constitutional protections rather than by citizens who depend on them. The inheritance case that began everything is finally closed, but the larger investigation into judicial corruption continues as federal agents follow evidence trails that lead to the Supreme Court itself. The threat to constitutional rights is more widespread, more systematic, and more dangerous than anyone imagined when Victoria first walked into that Montgomery County courtroom 18 months ago. Justice is served, but it requires constant protection. The Constitution is preserved, but it remains under constant threat. And federal agents continue their work to ensure that equal protection under law remains more than just a promise. It becomes a reality for every American citizen regardless of race, class, or political affiliation. The gavel falls one final time, but this time it falls on the guilty rather than the innocent. The scales of justice, thrown far out of balance by corruption and greed, are slowly returning to their proper position through federal intervention and constitutional enforcement. Victoria Blackstone's work continues, but her legacy is already secure. She proved that even the most powerful corrupt officials cannot escape federal justice when constitutional rights are systematically violated. Her investigation restored faith in the principle that no one is above the law. Not judges, not lawyers, not political networks that profit from denying justice to those who need it most. The courthouse in Montgomery County now operates under federal oversight with new judges, reform to procedures, and constant monitoring to prevent future constitutional violations. The marble inscription promising equal justice under law has meaning again, protected by federal agents who ensure that constitutional rights are more than just words carved in stone. But the most enduring legacy of Operation Fallen Shield may be the message it sends to future generations. The Constitution is not a museum piece to be admired from a distance. It is a living document that requires active protection by citizens willing to risk everything to ensure that constitutional rights remain available to everyone, regardless of who they are or where they come from. Victoria Blackstone proved that justice delayed is not justice denied. As long as there are federal agents willing to work 18 months undercover to gather the evidence necessary to hold corrupt officials accountable, her investigation demonstrates that the American legal system, despite its flaws, retains the capacity for self-correction when federal authority is properly applied to protect constitutional rights. The story ends, but the work continues. The investigation concludes, but vigilance remains eternal. The criminals are convicted, but the Constitution requires constant protection by those who understand that democracy survives only when equal justice under law is more than just a slogan. It is a daily reality for every American citizen.